feel but heard in the matter of Koza Ltd and another and Koza Altin Isletmeleri AS and others.
Can I just recap where we've got to and try and encapsulate what I was putting across yesterday? So, by far the largest issue in front of you is the question whether or not there is a serious issue to be tried. The first sub-issue within that, on which I was addressing you yesterday, is whether this is properly understood as a case which requires the English court to recognise anything. And if I may respectfully suggest, quite a few of the interventions from the bench assumed the answer to that question rather than analysing it. What we say, in short, is simply this, that when the court talks about enforcing or recognising a foreign judgment, what it means is giving effect, giving legal effect in this jurisdiction to the substance of that judgment for the purpose of disposing of a point in issue in these proceedings. And if you accept that as the starting point, and you then accept, as is the case, that there is no contested issue in these proceedings as to whether the directors of Koza Altin are the directors of Koza Altin. The court, therefore...
It's a contested issue as to whether they have authority to do what they're seeking
no,
to
it's
do.
not. That isn't the issue. The issue is whether this court should recognise, whether it should choose to recognise the authority that they do have. This court is not being asked to make a ruling on Turkish law. If you look, I won't go to, but if you look, the declarations that are sought and the injunctions that are sought are very clearly expressed as an invitation to the court not to recognise the authority that the directors do have. So the English court is not being asked to make a ruling of Turkish law, that these directors don't have authority under the lex incorporationis. Now,
just before you move on, can I just, to understand the parameters of where we are, and I think I know what your answers would be, but I'd just like to be clear. Suppose that we had a slightly different case where, well, two things. First, suppose that there had been a slightly different case where a Turkish court had appointed an attorney to act on behalf of the company. And the attorney were then seeking on behalf of the company to do the things that your clients are seeking to do. And suppose further, as we were supposing last night, that the judgment and everything associated with it was irredeemably corrupt. You would say the position is the same, would you?
Yes, absolutely.
And just my other scenario, in this case we've got a Turkish court appointing your clients as directors. If it were not an appointment, but rather that as a result of all the relevant judges being bribed, Turkish courts had declared your clients to be directors, purporting to apply Turkish law when actually it was a nonsense. Again, the position would be the same.
Yes, absolutely. Yeah. So the starting point is, as we would suggest, that these proceedings do not involve a challenge to the existence, under Turkish law, of the authority of the directors. Now, with that as a starting point, and if we accept, for the sake of this stage of the argument, that the SUA judgment is the source of the legal authority of the Koza Altin directors, the fact that the appellants are not seeking to challenge the existence of that legal authority under Turkish law means that the English court is not being asked to give effect to that judgment. It's not being asked to recognise the judgment as the word recognise is used in this area of the law. So one then asks, well, what is the issue in these proceedings in relation to which the appellants say that this court needs to decide whether to recognise the sewer judgment? And the answer from the appellants is, on analysis, totally circular. They say that the issue which they have raised is that this court should not recognise the authority that the Turkish directors have. So they are effectively saying that the purpose for which the issue of recognition arises is recognition. And in our submission, that is simply a legal nonsense. It is legally incoherent, because it simply ignores the true nature of the concept of recognition. And that, in our submission, is what Mr. Justice Trower was getting at. If we just look at paragraph 91 of his judgment, in the core bundle at page 122. Could I just invite the court, I won't read it out, but, and in fact it may not be necessary to read it now, but could I just invite you to note that we say that that is what he was engaging with in paragraph 91 and through 92, 93 and following. He accepted that analysis. In our submission, it's entirely right. So, with respect, the appellant's attempt to raise what they choose to call a question of recognition is pure bootstraps, because there is no issue in dispute in these proceedings in relation to which a judgment of the foreign court has to be recognised. And Malano Fran's authorities, if I could just briefly respond. So he went to 3 categories of authority yesterday on judgments in rem, judgments dealing with marital status, and the position of foreign appointed office holders. Now, collectively, what we would say in response to all of those authorities is that they illustrate how the court conducts the exercise of deciding whether or not to recognise a foreign judgment. But they provide you with no direct assistance at all in answering the anterior question, which is whether, properly analysed, a question of recognition arises at all. And we would suggest, the reason I say they don't provide any direct assistance is that if you look at what was in fact in issue, they do indirectly illustrate the very point that we are making. And I don't propose to go through all of them, but for example, under the first category of judgments in rem, the Castries and Imrie decision, the issue for determination in the English court was a property right in the ship. In order to determine that issue, which was in dispute, the court had to decide whether or not to recognise a French judgment which dealt with that property right. So that is a very clear illustration of a foreign judgment being invoked in order to determine an issue in dispute in these proceedings. Similarly, the marital status cases, we looked at von Lorang, where a happily married couple saw it more convenient to get a declaration of nullity in order to avoid the consequences of a Scottish woman being married to an Austrian. Again, the issue there was in the Scottish court whether or not that woman was married ever. And it was in relation to that issue in dispute in the Scottish proceedings that the validity of the German judgment in Rem, or no, sorry, the German judgment as to status was invoked. So again, it's a very clear illustration of a case in which there is an issue in dispute in relation to which the foreign judgment is being invoked as being determinative.
So
And-
if, sorry to interrupt
No.
you, but so if there was a challenge to the sewer judgment's appointment, authorisation of the trustees, and that would be a status question
If
that had been resolved by the sewer judgment. And if there was a challenge in this country to the question of whether the trustees had authority to be director, were authorised to be directors,
that would be a challenge to authority, and
Then-
that's not this case.
but you accept that in that situation, this court would have to engage in the
Yes.
question of whether or
Yes.
not to recognise the
Yes.
sewer judgment.
Yes.
Okay.
The third,
Sorry, go on.
I'm so sorry. The third category of case that Milan Friend relied on were the foreign appointed office holders, the receivers and liquidators. But again, that serves only to reinforce our analysis that what these cases are dealing with is situations where a litigant comes to the court asking this court to recognise that a cause of action or a power is vested in him by virtue of the foreign judgment. So a receiver comes to court asking the court here to recognise him, the receiver. Or the liquidator comes to the court asking the court to recognise him, the liquidator, to exercise the liquidator's power. That, again, is a very clear illustration of the situation where a foreign judgment is being invoked in order to determine or assist in the determination of an issue in dispute here. And as we say, simply because there is no dispute about the position in Turkish law, that is just not this case, and so this is not a case about recognition. And that, sorry,
Can I just try to understand it? I haven't looked properly at the particulars of claim, but just turned them up. So we're at core bundle, page 190 for the relief sort.
yeah, or yes, the claim forms, page 148, yes, I think the relief in the prayer at 112 is essentially the same. So what is being sought?
So just talk it through for a moment. 112.2, they ask for a declaration that what you've done isn't effective.
Yeah, because
And a reason for that is presumably what they asked for in 1. They say you don't have any authority.
well, that is the link they are trying to make, but our response to that is that the declaration in paragraph 1 is, we would submit a legally incoherent request to the English court to consider an issue which doesn't arise. You can't simply come to the court in the abstract. Again, as Mr. Justice Trower said, you can't make a freestanding request for recognition or non-recognition. It's got to be relevant to a disputed issue. If there is no disputed issue about the status of the directors as a matter of Turkish law, then as a matter of the law of the country of incorporation, Koza Altin has served the Section 303 notice.
I think I see where you're going, but I'm not quite sure I see that the analysis is quite what you're suggesting it is. I mean, you're saying there cannot be any dispute about it. I mean, it is on the pleadings in dispute. You say it's not something about which there can be a dispute.
We are saying that what is being sought is a declaration that the English courts do not recognise the authority of the trustees. That's what paragraph 1 says, and again, in paragraph 3, it's the same language, a declaration that the English courts do not recognise any authority of the SDIF appointees. So the question that is being raised in these proceedings is not, dear English court, please rule that as a matter of Turkish law, these are not the directors. The question is predicated on them being the directors, but
Is it?
the court is being asked to ignore, this court is being asked to ignore that fact.
I mean, just breaking that down, it isn't obvious from that that it's predicated on them being directors in the eyes of an English court. But leave that aside for a moment. 2, which is definitely ahead of substantive relief that can be sought, is presumably premised, at least in part, on the proposition that you don't have authority. Now, you say you do, but why isn't that an issue?
Lord, I don't think I can do better than offering the answer that we have given, which is that recognition can only be a relevant concept in relation to the issue that it addresses.
Well, this runs the risk of becoming what can only be described as a pleading point, frankly, Mr. Crowe, because if you go into the body of the pleading, you can find all sorts of assertions by the claimants that, for example, the trustees, I'm just looking at paragraph 39 on page 166, no grounds for the appointment of the trustees are shown by the judgment, and they then talk about there and elsewhere about the fact that the criteria laid down by Article 133 of the TCPC were not satisfied. And that is surely an allegation that the people who were appointed as directors effectively had no authority because the relevant statutory provisions weren't satisfied.
Well, with respect, my Lord, what I'm taking is not a pleading point. I'm addressing you by reference to what is the basis upon which the whole claim has been brought, and that is quite clear from paragraph 39 of the judgment below. Second half of page 112. I don't want to trawl back through the expert evidence, but Mr. Justice Trower was entirely right when he said in the 6th line, Koza Altin's expert evidence makes plain that as a matter of Turkish law, the individual defendants are the directors of Koza Altin. This is not contested by the claimants, nor is it contested that Turkish law treats court decisions as being valid and effective until set aside, and none of the decisions relating to the appointments in the present case have been set aside.
And that's obviously all true. And you say, well, matters relating to who's on a board or whatever are decided by the law of the place of incorporation. Here it's Turkey. That's that. But to say that as a matter of Turkish law, these individuals are recognised as directors doesn't, on the face of it, deal with the thrust of the case against you, which is their status as directors derives from a judgment which the English court should not recognise. Now, you say that's not a question that can be asked, but it is a question raised by the case.
I entirely agree. The words on the page of the pleading purport to raise that issue. The analysis which we are offering is that it is a legally incoherent request, and it simply fails properly to recognise what the word recognise means in relation to giving effect to a foreign judgment. I mean, the sewer judgment has effect in Turkey, and it only needs to have effect in Turkey for the Turkish directors to have authority on behalf of the Turkish company. They, the directors, are not doing anything here. What they do in Turkey may have consequences here, but if the court simply acknowledges those consequences, here is a Section 303 notice, served in the name of Koza Altin on the authority of the directors appointed under the law of its incorporation. If the court acknowledges those consequences here, this court is not giving effect to the sewer judgment. It's not recognising in the sense of giving legal effect in this jurisdiction to the judgment. Because the only relevant content of the judgment is to identify who the directors of Koza Altin are, and that is not an issue in dispute. And that is why, if I can now get on to Williams and Humbert, why Williams and Humbert gives you the sort of the window through which to view this. My learned friend sought to distinguish Williams and Humbert by saying, well, that was a case about enforcement, and it was a case about foreign penal legislation, both of which are true as a matter of fact, but they miss the point of the significance of the judgment. The significance of the judgment for our purposes is in relation to what the English court regards as relevant, where legal proceedings are brought in this jurisdiction to vindicate an English law claim. And where that claim is being advanced by a foreign corporation whose ownership or management may indeed have been changed under the law of its incorporation. But is any of that change relevant to the pursuit of the English law cause of action? Now, strictly speaking, of course, Koza Altin isn't pursuing a cause of action, it's relying on shareholder rights, but the two situations are essentially indistinguishable. So what we submit is that when you look at the analysis in Williams and Humbert, as I say, the significance of it is what was regarded as a relevant issue when deciding whether or not to allow the English proceedings to go ahead. Now, the judgment is in bundle 1 of the authorities at tab 15. And I'm sure you recall the facts very simply. There was an expropriation in Spain by legislation, and as a result, English subsidiaries brought proceedings here seeking to enforce English law rights in relation to copyright and breach of fiduciary duty. We'll just skip very quickly through, first of all, so tab 15. If we look, first of all, Mr. Justice North, as he then was, heard it at first instance. And if we just look at page 34, sorry, I'm using the electronic, I think, numbering at the bottom of page A342. And you'll see in the very first paragraph, what the judge says is, these are interlocutory applications in two related actions, in which it is sought to raise the defence that the proceedings are an attempt to enforce foreign expropriatory laws, which either ought not to be recognised or ought not to be enforced in England. I merely draw that to your attention because the judge is making no difference of principle between enforcement and recognition. They are flip sides of exactly the same concept, which is giving legal effect in this jurisdiction to the content, to the substance of a foreign judgment. Enforcement, obviously, is where you are relying on it proactively. Recognition is usually where you are relying on the foreign judgment defensively. But they are conceptually identical because what they involve is an invitation to the English court to give legal effect here to the foreign judgment or legislation, whatever it is. If we then flip on to page 363, electronic page 363, we see Lord Justice Fox in the Court of Appeal. So I want to go as quickly as I can. Could I just draw to your attention page 352, DG. I don't ask you to read that now, but that, sorry, I shouldn't have passed over everything Mr. Justice North said.
352.
352 D to G is where he captures the irrelevance issue. Lord Justice Fox at page 363, just below E, he says, I return to the central issue, the argument that the tradesman's action is in substance indirect enforcement of the decrees. In my opinion, that contention is without foundation in English law. My reasons are as follows. The purpose of the decree, so far as relevant, was to obtain control of Rumasa SA. With that would go control of Williams and Humbert Limited. All that has been fully achieved. The decrees are recognised as valid by English law and have been carried into effect. The shareholding in Rumasa SA has been transferred. To talk of enforcement of the decrees, directly or indirectly, is beside the point. So far as the decrees are concerned, there's nothing left to enforce. In that respect, this case is quite different from the Peter Buchanan case, where the United Kingdom revenue law still needed to be enforced. It is said, however, that there is attempted enforcement of the decrees in that Williams and Humbert Limited is seeking to recover its trademarks. That is not an enforcement of the decrees directly or indirectly. It is an enforcement of the ordinary rights of Williams and Humbert. Under English law, the decrees form no part of the cause of action. Now,
that's making the point that it's one thing if what you do is you come to this jurisdiction and effectively ask the court to give effect to a foreign penal law by way of enforcement or whatever, because you have yet to as it were, to finalise whatever it is that needs to be done.
That's right. That's giving effect.
Here is everything's already been done in Spain, so that then
that's right.
The mischief he's addressing is foreign penal laws cannot be enforced directly.
That's the context. That's the context in which he is making his comment on irrelevance.
I'm not.
The context.
Disagreeing with your analysis.
I'm grateful. We're all agreed. The factual context of this case was foreign enforcement of foreign penal legislation. That's not factually the context of our case. No. But in principle, exactly the same issue arises here. Namely that everything that needs to happen under the law of the country of incorporation has happened. The directors have been replaced in Turkey. They are the directors. Koza Altin is not coming to this jurisdiction asking the English court to give effect, to recognise the director's appointment. Koza Altin is exercising a right under English law, just as Williams and Humbert was seeking to vindicate its rights under English law. Where a litigant, a corporate litigant, comes to this court seeking to exercise a right conferred by English law, it is not asking this court to give effect to the process by which its directors happen to have been appointed. It is simply asking the court to rule on its English law rights. So it is simply not a question of recognition at all. And one gets the same when you get up to the House of Lords. The House of Lords judgment starts at page at Sorry, 392. Sorry, I had it. And you'll see Lord Templeman is giving a leading speech with Lords Scarman, Bridge and Brandon all agreeing. If I just draw to your attention at 393, between B and C, Mr. Justice North, after hearing arguments which spanned 7 working days concluded that the answer was obvious and that the ownership of the plaintiff's shares in each action was irrelevant. He therefore refused to allow the defendants to plead the compulsory acquisition as a defence. The majority of the Court of Appeal agreed. Lord Justice Lloyd thought the problem was more difficult and dissented. So it's entirely clear there that what we have, both at first instance and as we've seen in the Court of Appeal and as recognised here, the basis of the decision was that what had gone on in Spain was irrelevant to the issue that arose in England, because the issue that arose was a company seeking to enforce a right under English law, just as Koza Altin is seeking to vindicate its shareholder rights as the sole ordinary shareholder in Koza Ltd. And those rights arise under the Companies Act, not by virtue of anything that's happened in Turkey. Koza Altin didn't become a shareholder in Koza Ltd because of anything that happened in Turkey. It held the shares in Koza Ltd before any of the matters complained of, and its rights as a shareholder in Koza Ltd arise under English law, not by virtue of anything that's happened in Turkey.
But that isn't quite what's an issue. The issue is not whether Koza Altin has rights. The issue is whether you are entitled to exercise those rights.
To pose the point in that way assumes that is a relevant issue in relation to which recognition can be invoked as a legal concept. And my argument, I think I've probably got it across. My argument is that isn't properly described as an issue, because an issue is something the English court needs to engage with in order to decide the matters in dispute. And you can't have a completely circular issue about recognition for the sake of deciding recognition.
And I see your point, but in terms of this particular paragraph, it's a distinct point, isn't it? Because ownership is different from asking whether someone has authority to do something.
Well, the two, once you own something, as the shareholder, you appoint the directors and through ownership have control.
Not in this case.
Well,
I mean,
sure.
one of the oddities of this, what makes this case so unusual is that the directors have no connection with the owners.
No, absolutely. What makes it so unusual is, to do him credit, Mr. Ipek has brought proceedings 6 years ago with no beneficial ownership of any interest in Koza Ltd, and he has retained de facto control over it and its money for the last 6 years. And the sole owner of the ordinary shares, my client, has had absolutely no control and has watched tens of millions of pounds going out of its own subsidiary.
But spinning it differently, your clients aren't anything to do with the owners of your company. And the Ipek family do have a substantial stake in your company.
Yes, that is certainly true, although it is majority publicly owned.
41% is the Ipek family.
I think that's, I'm grateful. So just to wrap up, I don't want to spend too long, but can we, so 393, B to C, irrelevance is the significant point in this case. And then if we could look at 395, just above letter G, where Lord Templeman says, it is, in my view, doubtful whether the Spanish law dated 29th of June 1983 can properly be described as a penal law for present purposes. But in any event, the plaintiffs in the trademark action and the plaintiffs in the banks action are not seeking to enforce the Spanish law. In the trademarks action, the plaintiffs, Williams and Humbert, and in the banks action, Rumasa, Ereth and Nott, are seeking to enforce English private law right, enforce English private law, which can be invoked, subject to exceptions not here relevant, by a plaintiff of any nationality against any defendant within the jurisdiction, against any property within the jurisdiction. And he then quotes Mr. Justice Norse, that the object of the law was to acquire direct ownership and control of Rumasa and the two banks, and direct ownership and control of Williams and Humbert. That object has been duly achieved by the perfection of the title, the state's title in Spain. Accordingly, on a simple and compelling view, there's nothing left to enforce. I agree. And that, in our submission, in substance, is the position here. It's not a question of transferring ownership, but it is a question of effecting management change in Turkey. That's been done. What is being sought here is not the perfection of the directors, of the Turkish directors' control over Koza Altin. What is being sought is the enforcement of Koza Altin's rights under English law. And just to finish with this case, page 39, electronic page 397, just below C, if the principles of English domestic law and international law are applied, and if the plaintiffs succeed in establishing liability against any of the appellants in tort, misfeasance or breach of federal issue duty, then an English court will grant the appropriate relief. If the Mateus family had remained in charge of the Ramassa group, perhaps no action would have been brought by any of the companies comprised in the Ramassa group against the appellants, but that consideration is irrelevant to the actions which have now been brought. And that's again exactly our position. What this judgment is saying here is that it may well be that the consequence of the change of control in Turkey is that the Section 303 notice was served. But the service of the Section 303 notice is not an attempt to give effect in English law to anything that has happened in Turkey. It is simply a consequence of a management decision in Turkey taken by people who are duly appointed under the law of that jurisdiction. And then just to look, finally, a few other points. If we look at 399, the House of Lords there is dealing with essentially an attempt to do exactly what my learned friend has been doing. You'll see at the foot of 398, reliance was placed on a receiver case, Frankfurter and Exner. And at the top of 399, what Lord Templeman says is Mr. Littman sought to rely on this decision, but the present case does not involve enforcement of a foreign law, which offends the principles of human rights or the enforcement of a title to property conferred by Spanish law to property situated in England. The Trademarks Action and the Banks Action are actions by English and Spanish companies to recover property to which, according to their pleadings, they were entitled before the enactment of the Spanish law, to which they remain entitled. And exactly the same applies here. It happens to be an enforcement. It's an exercise. What Koza Altin is doing is exercising a shareholder right conferred by English law, conferred on Koza Altin under English law, long before and not dependent on anything that has happened in Turkey. And finally, just page 401, between E and F, my lords, on principle and authority, the appellant's attempt to persuade an English court to ignore the effect and consequences of the Spanish law is misconceived. And that, in our submission, there is a very clear and important conceptual distinction between the English court accepting the consequences of something which has fully happened abroad, and the English court giving legal force, giving legal effect to the ruling of a foreign judgment. And again, the fact that this judgment is based on the irrelevance of what was being pleaded about what had happened in Spain. Just a final reference to irrelevance on page 403 at letter D.
And just before you look at that, the consequences of what has happened abroad is the 303 and 305 notices. But what are you saying has happened and is complete? The appointment of the trustees to the board.
Exactly.
And what about the management decision that steps should be taken to issue the 305 notice?
Well, that is a consequence of the appointment.
That's not part of the steps. That's
not part of the step, because that isn't a judicial ruling in Turkey. That's a decision by the duly appointed directors, who have been appointed pursuant to a judicial decision. Let us assume. So that is, with respect, why we say the judge below was right to accept that Williams and Humbert does provide, clearly not dealing with identical facts, but why we say it does provide the closest analogy, and why all the in rem matrimonial nullity and receiver cases that my friend relies on miss the point. And if you accept that analysis, then with the greatest respect, the appellants can't change what the issues are, what the issues that can properly be raised in these proceedings. They can't change what those issues are simply by the cosmetic device of joining the directors personally. The dispute is, are these Section 303 notices valid? The notices were not served by directors exercising personal rights. The notices were served by the company, unquestionably by the people who are its directors. You can't alter the substance of the dispute simply by joining directors personally and saying, aha, we don't like the fact that you're directors, so we're going to ask the English court to ignore the fact that you are. That, in our submission, is not a legitimate deployment of the concept of recognition. Can I just, while we're doing a bit of case law, look very briefly at the Central Bank of Venezuela case, because that doesn't assist my learned friend on this at all. The issue I'm addressing you on is, does this case raise what can probably be described as a question of recognition? The Central Bank of Venezuela case was totally different. It doesn't begin to address the question of whether a question of recognition arises at all. In fact, having said I'm going to turn to it, I may just deal with it without opening it, because you saw it yesterday. What you will recall that the dispute arose because there were two claimants to being the president of Venezuela, Maduro and Guaido. The first question was simply, who should the English court regard as the head of state? And the answer to that question was entirely based on what's called the one voice principle, which is that the Foreign Secretary says X, and the court, being another branch of the UK, isn't in a position to say Y. So one voice, Foreign Office says yes, courts say yes. Second question then was whether or not the appointments by that person, properly recognised as the president, whether appointments made by him could be impugned before the English courts. And that raised an act of state issue. As a sub-issue of the act of state issue, the point was taken by the Maduro camp that the Supreme Tribunal of Justice had said Guaido isn't the president. So in order to decide whether or not the court was bound by the one voice principle in the context of a case where there were conflicting voices, so to speak, from the foreign state. There was the legislative choice in favour of Guaido, and there was a Supreme Tribunal of Justice voice saying not Guaido, Maduro. In that context, for the purpose of answering the question as to who the English court should regard as the head of state, there was an issue as to whether the English court should recognise the decision of the Supreme Tribunal of Justice as, in a sense, presenting an exception to the one voice principle. Does the English court have to listen to a judicial ruling in a foreign country, such as, so to speak, to trump what the Foreign Secretary says is the UK's attitude to who the president is? So, self-evidently, there was an issue in dispute here which turned on whether or not the English court should give effect to a judicial ruling overseas. All of that is very interesting. But it doesn't begin to answer the question, which Williams and Humbert does answer, which is where a company's ownership or management has changed hands under the law of its incorporation, and it then brings proceedings which are vested in it by English law and not dependent on anything that's happened overseas. Is that a question of recognition at all?
Can I ask a question about this? I haven't looked properly to see what the Venezuelan court was ruling on. Supposing, which I don't suppose is the case, but supposing the Venezuelan court had ruled that the Maduro board were the directors of the Central Bank of Venezuela, would that have been the end of the matter?
The question, if they had ruled that the Maduro board were the board, would that have been an end of the question? No, it wouldn't have been, because the one voice principle says there can only be one head of state for each country, and the foreign secretary gets the determinative word on that. The English court therefore has to accept that unless there is some reason not to do so.
But why would that matter on this basis? Because the identity of the board would be determined by the law of the place of incorporation.
Yeah.
A Venezuelan court would have ruled on who the directors were. Why wouldn't that be the end of it?
Well, because the question whether or not the identity of the board entirely depended on who the president was. There was common ground that the president, whoever it was, could appoint the board. So the answer to the question, who is the board, is answered by the reference to the question, who's the president?
But that suggests
Unless
you can go behind what the law of incorporation says about who the board are.
My Lord, all it illustrates is what are the situations in which an English court will consider whether or not to recognise a foreign judgment. That's the issue I'm trying to address you on at the moment. What are the circumstances in which that issue is a relevant issue for this court to consider? The circumstances in that case were that it did have to consider it because there was the one voice principle which produced the answer, it's Guaido is the president, therefore the Guaido board is the board. The answer, an attempted answer, it wasn't actually resolved because it wasn't one of the preliminary issues that got all the way up to the Supreme Court. The Supreme Court simply said, well, that is now something that does have to be considered. So all the case does is to provide an illustration of a factual situation in which the English court was called upon to consider whether or not to give effect to a foreign judgment. it doesn't assist you in deciding that this is one of those cases, because the facts in that case were so unique, as I say, in which the court repeatedly says it is faced with a situation in which there are conflicting voices from the foreign state. Because, as I say, the legislature had said Guaido and the Supreme Tribunal of Justice had said Maduro. So I don't...
Sorry, can I just take it a bit further? I'm just looking at the judgment now. If I look at paragraph 28, this is page 1128 of the bundle.
Yeah.
The whole range of those judgments to that effect.
So the STJ issued a judgment holding that the appointment of the Guaido board was unconstitutional, nullity and of no effect. So that's a ruling from court in the state of incorporation that the Guaido board is not validly appointed. I mean,
Yes.
Why, on your case, is it proper to go behind that?
It's proper to go behind that precisely because of the circumstance in which that came to the court's attention, so to speak. Because the one voice principle says it is the Guaido board. It's common ground in the case that the board of the central bank is appointed by the president. The first preliminary issue that was determined by the Supreme Court was that the one voice principle requires the English court to accept whatever the Foreign Secretary says in answer to the question, who's the president? The Foreign Secretary had said Guaido, therefore the one voice principle requires the court to say Guaido. That being the case, the court then has to answer the ancillary question, well, since the Supreme Tribunal of Justice has issued this ruling, does that ruling detract from the finding which we are forced to make by applying the one voice principle? So, as I say, all that case does is to illustrate for you on truly unique facts, unlikely to be repeated.
Well, I'm not sure about that. Because
Well,
no, I'm not sure about your last point as to what's really going on here. Because I mean, if you go to paragraph 170 on page A1174, that's where Lord Jones deals with the issue of what's going to happen when it goes back to the commercial court and lays down some guidelines, including that because of the need for the executive and the judiciary to speak with one voice on issues related to the recognition of foreign states, governments and heads of states, to the extent that the STJ reasoning was that the reason why the acts of Mr. Guaido and his board were unlawful nullities was dependent on the view that he wasn't president, that would be contrary to English public policy and wouldn't be given effect to in England. So there's a much broader challenge on that basis. I mean, what we said against you here is, well, true it is, it's a different factual scenario, but what's being said is the English court should not give effect to these Turkish judgments because they were corrupt.
But it is your point, Mr. Crowe, not the point that the reason why the English court even got into that question in the Venezuela case is because of the one voice principle.
exactly.
We don't have that background. No one
That's
is
certainly true.
suggesting that this board of directors is not the board of
Exactly.
directors by virtue of the one voice principle or by virtue of any other
Exactly.
principle.
The whole, I mean, if one gets it most clearly from paragraph 156, which was, I think, drawn to your attention, although it may not have been read in full yesterday, so page 1169. The situation arises because the court, just between C and D, this court is confronted with the conflicting positions adopted by the executive and the judiciary of Venezuela. That's why the problem arises. The question arises, therefore, whether in such circumstances, the foreign act of state dropped in the form of Rule 2 requires courts in this jurisdiction to defer to the acts of the executive of foreign state in priority to recognising the rulings of its judiciary. That's why the question arose, because there were conflicting voices. it should be noted in this regard that it's the pleaded case of the Guaido Board that this Supreme Tribunal of Justice is not to be regarded by an English court as an independent court of law. That issue, however, falls outside the preliminary issues in this appeal, and consideration of it, if necessary, would have to be deferred. At this stage of the proceedings, we are concerned with the submission by the Guaido Board that it is entitled to succeed on the basis of act of state, quite apart from the position in the municipal law of Venezuela. So the only legal issue the Supreme Court was dealing with was essentially, does the one voice principle trump anything that the courts of the foreign jurisdiction have said, irrespective of how well-founded that judgment might be. That's why the issue arose, and that's why this case doesn't provide you with any assistance in deciding whether there is an issue of recognition in our case, because there are no conflicting voices from Turkey, from Turkish executive and or judiciary or legislative bodies. They are speaking with one voice. So on my first main point, which we have now finished, we submit that Williams and Humbert provides the prism through which the question on which the court below decided it, namely, is this properly a case involving recognition at all? And on that point, the Venezuela case provides no assistance at all. Can I then move on, because I have quite a lot of ground yet to cover. So that's the first main point under no serious issue. This isn't properly understood a recognition case at all. If you reject that argument and you consider that it is necessary for the court here to recognise something from Turkey, the second question, and this is ground two of our respondents. I'm not going to go through the appeal and the respondent's notice sort of in the order in which they appear on the page. I'm trying to deal with it sort of in a conceptually logical way. So, assuming you're against me and you think, yes, well, we do have to recognise something from Turkey, the second main sub-issue under serious issue to be tried is what needs to be recognised. What is it that needs to be recognised or not recognised from Turkey? Is it, in fact, the sewer judgment, or is it something else? My learned friend says it's the sewer judgment, and he says that all subsequent appointments are contingent upon the validity of that. In response, we say that the attack on the sewer judgment is misplaced. We do not need to rely on it, and we can and do rely in the alternative on legislation and administrative decision-making by the SDIF. And, for that matter, a continuation of the trustee's appointment by a court other than sewer, and indeed other than the peace criminal judges, for reasons I will explain very shortly. Before getting on to the substance of that, I just need to deal with one preliminary point, which is that my learned friend says we didn't run this argument in the court below. In our submission, that is demonstrably incorrect. We did. It is mentioned, although not ruled on, by the judge below at paragraph 87. I don't ask you to go to that in the interests of time. Could I just ask you to note that paragraph 87 refers to the argument. More compellingly, we dealt with it at some length in our skeleton argument in the court below, and I will just ask you to turn the pages of this. So supplementary bundle 2, tab 23, page 361. And I'll just take you to this because it captures both this point and also our reliance on the Turkish Constitutional Court.
Sorry, can you give us the reference again?
Yes, of course. It's supplementary bundle 2, tab 23 at page 361. And I just want to turn the pages of this very briefly, simply because my learned friend has taken against us two arguments that we didn't run particular points in the court below, and both of them are covered in this. Both our ability, our entitlement to rely on things subsequent to the sewer judgment, and secondly, we'll come on to it later, but I'll deal with it now because it's on the same page, the ruling of the Turkish Constitutional Court. So you'll see at paragraph 115 of our skeleton in the court below, under the heading Other Points, although the point doesn't arise, because that's what we were saying we will rise on our first point, the claimant cannot. Claimants cannot and do not even attempt to impeach in this jurisdiction all of the decisions they would need to, even if this were a case about recognition of foreign decisions. And then we set out the test from Maximov. The fact that a foreign court decision is manifestly wrong or is perverse is not sufficient. It must be deliberately wrong, and the evidence showing that it must be must be cogent. The burden is even heavier when decisions of multiple courts are in play. In this case, the chain of decisions which led to the appointment of the Koza Altin directors is set out above. Amongst those decisions are a decision of the Turkish Constitutional Court and the European Court of Human Rights, which held it was capable of affording an appropriate redress, various decisions of the SDIF, which must by law be taken autonomously and independently of any government influence. Nowhere in the claimant's extensive evidence is there any attack on the bona fides of the Turkish Constitutional Court, quite the reverse. The suggestion is that one of the problems with the Turkish legal system is that the decisions of the Constitutional Court are not properly implemented. Nor is there any specific attack on the specific decision of the Constitutional Court of the 28th of May, dismissing Mr. Ipek's appeal. Similarly, no evidence that the SDIF's decisions in relation to the appointments of the KA directors to Koza Altin's board were improper in any way. Again, this means that any non-recognition of administrative decisions case could not get off the ground. We do say clearly we rely on the decisions of the SDIF, and indeed the judge himself recites the material upon which we relied in front of him in paragraphs 37 and 38 of his judgment. Core bundle page 111. While these interlocutory steps are taking place in the 2016 proceedings, there were further developments in Turkey which had an impact on the affairs of the Koza Ipek group. On the 1st of September, Statutory Decree 674 was promulgated, enabling the powers of the trustees, like those of other trustees appointed in similar circumstances, to be transferred to a state organisation, the SDIF. This was given effect in relation to Koza Altin by an order made by another criminal peace judge on the 6th of September 2016. Shortly thereafter, on the 22nd of September, the SDIF appointed a new board of directors for Koza Altin. There was then a further decree which transferred the director appointing powers of the SDIF to the minister, with whom the SDIF was affiliated. The minister was then empowered to delegate the power back to the board of the SDIF, a power which was exercised in November 2016. In January 2019, the Ankara 24th High Criminal Court ordered the continuation of the trusteeship.
None of those administrative or legislative decisions could have had any effect in this case in the absence of the sewer judgment, because it was all about transferring from one position to another. Is that right?
Well, that is the argument that is put.
I know it's the argument, but isn't it the fact? Because looking at the expert evidence and the text of the decrees, they're all predicated on there having initially been a judgment of the criminal peace judge that initially put the trustees into the board, appointed them as directors.
With respect, I don't think that is right,
Okay.
my lady. So first of all, if we just look at the law that's referred to, the decree, 674, which is in the second supplementary bundle 2, tab 34. And I quite agree, page 395, I quite agree it uses the word transferred. But what it is doing is transferring powers that are being exercised. It's
Well,
not
It says powers of the trustees who have been serving in companies
in respect.
of which it was decided
Yeah,
that a
which,
trustee be appointed
Yeah.
under Article 133.
which factually describes our case.
That is, and this is one such case.
Yeah,
And therefore it's
That
all
was decided.
predicated upon there having been a decision by a judge that a trustee be appointed under Article 133.
which factually is what has happened.
But if there hadn't been the sewer judgment in relation to this particular board, none of these laws could have effected changes
That
to the
is,
board,
as a matter of chronology, true.
right?
But it does not lead to the legal conclusion which my learned friend would wish, which is that the legal validity of the powers exercised by the SDIF is predicated on the lawfulness of the sewer judgment. All this is saying is that where factually powers have been exercised by trustees, those powers are now being transferred. The legal validity of the powers vested in the SDIF is not predicated on the correctness of the sewer judgment. It is simply predicated on the fact that there was a sewer judgment, which there was. And if one just looks also at the expert evidence in the other supplementary bundle 1 at tab 15. So our expert, Mr. Dolger, and if we turn to page 223, you'll see at paragraph 55 he quotes the decree we've just seen, and then at 56 he says the fundamental legal basis for the appointment of the SDIF as trustee under Article 133 of the Code is these two paragraphs, not the sewer judgment. So the appointment of the SDIF as trustee, the basis of it in Turkish law, is the legislative decree. And the other point, which is dealt with in a single sentence, but it is a highly significant sentence in the judgment below, at paragraph 38, which we just saw. In January 2019, the Ankara 24th High Criminal Court ordered the continuation of the trusteeship. The trusteeship for the last 3 years or so has been continued not on the basis of the sewer judgment.
Can you just have a look at that decision? We got that.
Yeah, we do. It's in tab 41 of the second. Well, when I say we have the decision, I think what we've actually got is an extract. I don't think anybody exhibited the entirety of the decision. And do I mean 41? Yes, I do. Tab 41, it's page 452. I have been instructed by those behind me that they think there may be in fact a typo. It should, we believe, be 2020, but I don't think anything turns on which year it was. We've got the original first and then the translation.
The translation
At 452.
at 452 below the boxes says
2019.
The decision was held on the 9th of the session was on the 9th of January 2019.
Yeah, it does.
And that's what the Turkish says.
It does seem to also, yes, I agree. I just mentioned it because it had been mentioned to me. Nothing, I think, turns on it. And you'll see the decision, it's the middle three lines between the whole bunch. Continuation of the trusteeship measure until the finalisation of the judgment in respect of the companies to which trustees have been appointed, and continuation of the trusteeship duty by the Savings Deposit Insurance Fund. Turkish acronym being TMSF, what we're calling SDIF. So, in our submission, it is simply a matter of record that the sewer judgment is not now the legal source of the trusteeship under which directors are appointed. That fact, then gives us a further argument which we raised in our supplemental skeleton, which is that on the basis of the Venezuela judgment, far from that judgment presenting us with any problems, it provides us with a further reason to uphold what is an argument under ground 2 of our respondent's notice, namely that this court is not being asked to recognise a judicial decision at all. What it's being asked to do is to, assuming recognition is in play, it is being asked to recognise appointments made by the SDIF, which are executive acts, not judicial decisions. And with that in mind, one has to go back to the Venezuela case and just see what it has to say about executive decisions, executive appointments. If we go, so it's Authorities Bundle 2, tab 30, page 1161. You'll see page 1161, paragraph 135. Yeah.
Yeah.
You'll see 135. It appears, therefore, that a substantial body of authority, not all of which is obiter, lends powerful support for the existence of a rule that courts in this jurisdiction will not adjudicate or sit in judgment on the lawfulness or validity under its own law of an executive act of a foreign state performed within the territory of that state. The rule also has a sound basis in principle. It is founded on the respect due to the sovereignty and independence of foreign states, and is intended to promote comity in interstate relations. While the same rationale underpins state immunity, the rule is distinct from state immunity is not required by international law. It's not founded on the personal immunity of a party directly or indirectly impleaded, but upon the subject matter of the proceedings. The rule does not turn on a conventional application of choice of law rules in private international law, nor does it depend on the lawfulness of the conduct under the law of the state in question. On the contrary, it is an exclusionary rule limiting the power of courts to decide certain issues as to the legality or validity of the conduct of foreign states within their proper jurisdiction. It operates not by reference to law, but by reference to the sovereign character of the conduct which forms the subject matter of the proceedings. In the words of Lord Cotton, it applies whether it be according to law or not according to law. I can therefore see no good reason to distinguish in this regard between legislative acts, in respect of which such a rule is clearly established, and executive acts. The fact that executive acts may lack any legal basis does not prevent the application of the rule.
So even if the sewer judgment has no legal basis in international law,
Well, even in Turkish law,
in Turkish law, it doesn't matter.
it just doesn't matter, because otherwise this court would be being asked to do exactly what paragraph 135 says you can't do, which is to sit in judgment on the lawfulness in Turkey of what has been done under Turkish law. That, no doubt, is why the pleading is couched as it is. You will recall the Chancellor suggested to me I was merely taking a pleading point. I'm not. I am pointing out that the issue, and indeed the only issue, that these claimants can properly raise is not please rule as a matter of Turkish law as to whether or not the SDIF has acted lawfully under Turkish law. It is essentially saying, okay, well, that is what's happened in Turkey. We can't ask the English court to second judge it, but we can ask the English court to ignore it, which is how he gets into his...
Your point here, I mean, in a sense, you've got 2 points, haven't you? One is that the January 2019 decision is a standalone decision to continue the trusteeship.
Yep.
It doesn't appear to be based on the sewer judgment as such at
Exactly.
all. And to the extent that what it's continuing is the trusteeship under the auspices of the SDIF, that is, or those were executive acts, so that even if the sewer judgment was a corrupt judgment, the fact so that it could be said, well, there was no legal basis for this executive decision to transfer the trusteeship to the SDIF. That doesn't make any difference. This court cannot interfere unless we get within one of the exceptions that he goes on to describe from Justice Ricks in Newcos.
Exactly, which is where my learned friend then bumps up against the problems of the Turkish Constitutional Court and the European Court of Human Rights. But we'll come on to that in a moment.
Yeah,
but
I know we'll
yes
come on to that.
is the answer.
That's the...
Essentially, the points we've got are both that there are subsequent judicial rulings which post-date sewer, which are not in any sense contingent upon the correctness of the sewer judgment, namely the 24th Ankara High Criminal Court. And there is subsequent legislative action, Decree 674, which was turned into Law 6758, subsequent legislative action authorising the SDIF to appoint, and then there are SDIF appointments.
Can I just try breaking that down for a moment? I mean, suppose the sewer order had not said what it did say, but rather had said that it was conferring power on the SDIF to appoint trustees, and the SDIF had then done that. Would you then say, well, it doesn't matter whether or not the court might doubt the effectiveness of the sewer judgment?
So is the question being asked on the hypothesis that nothing had then happened after the sewer judgment?
No, I'm assuming for the sake of argument, the sewer judgment says, SDIF, you have power to make the appointment, and the SDIF then makes an appointment. And we assume for the sake of argument that this court is entitled to look at the validity or whatever of the sewer judgment, would the fact that an appointment had then been made by the SDIF mean that this court could not inquire any further?
Yes, absolutely.
And
Because
you
it-
would say that's what Lord Jones is saying at the end of paragraph
Exactly,
135.
and you know, really pithily put by Lord Cotton.
So once you get to the point where the appointment of the trustees who are now in place are appointed by virtue either of an executive act within paragraph 135 of Venezuela, or a subsequent completely independent judicial decision not contingent on sewer, then you would say, well, it's all very interesting what happened in the past, even if Mr. Scott is right that it was all corrupt. The fact is, it's water under the bridge.
Yes.
And just pursuing it a moment longer, we see that this applies in relation to executive acts of a foreign state. Is anything done by an arm of the foreign state, an executive done by the foreign state in exercise of sovereign power or whatever?
Yes, that's what the SDIF is.
Delegated ministerial authority.
Because
So
it is,
it by
just looking
definition,
back, sorry.
anything that is done by the SDIF is, for this purpose, an executive act of a foreign state.
Yes, it is. If we just look back at paragraph 138 of the judgment below, that's the easiest place to capture it. Sorry, not 130, 38, sorry.
38. So the
It's quite
minister
condensed.
delegated the power back to the board of the
Exactly.
SDIF.
So the SDIF, which is itself a public body,
Yeah.
is exercising a
Yeah.
power.
He says in the previous paragraph it's a state organisation.
That's right. So-
And this in a sense ties in with your submission about Williams and Humbert, doesn't it? Because the Lord Templeman recognises that what was pleaded in that case might have had some legs, if I can put it that way, if it were the case that foreign expropriatory laws were regarded as abhorrent in this jurisdiction, contrary to English public policy. And that's the exception that Lord Justice Ricks recognises in Newcos. But unless you get within that exception in the case of executive acts, so there you've got the Foreign Executive Act is the act of the Spanish government taking over the companies in Spain, can't be challenged unless it's contrary to English public policy or international law.
Absolutely.
Can I just test the limits a moment longer? Suppose that there had been no sewer judgment and no basis at all in Turkish law for the SDIF to purport to appoint directors. But nevertheless, it had issued a decree saying from here on, the trustees, the directors will be X, Y, Z. Would that have been effective?
Yes, it would. Applying paragraph 136, 135. That is so, whether it is according to the law or not according to the law.
Well,
Of
unless
foreign
of course it's
state.
contrary to public policy.
Absolutely.
That it may lack any legal basis.
Yeah. Absolutely. It is a brutal rule, but it is absolutely based on principle.
As explained by Lord Lloyd Jones, one can see the sense of it.
Yeah,
It's
absolutely.
effectively a rule that it's a
Respect.
self-denying ordinance,
Absolutely.
and that's actually the rationale of so-called the so-called rule, the dicey rule. I forget which rule it is now, but the one that they deal with in Williams and Humbert as well, the tax rule, which this court considered in recently in the SCAT case.
Yes. Yes. Yes.
It's a self-denying ordinance. This court doesn't concern itself with executive acts of a friendly foreign state.
And so that is our second sort of main point, so to speak. Just to deal very briefly with a couple of my land friends' responses. So First, he said it's legally incoherent for us to contend that the court here should recognise an executive appointment if it was, in his language, premised upon a judgment which should not be recognised, which is a superficially attractive way of putting the point, but in substance doesn't have anything for a multitude of reasons. First, it ignores the very facts which my learned friend concedes, which is that the test for this court to recognise or not recognise executive acts is entirely different from the test applicable to recognising or not recognising judicial rulings. If there is a different test, it is not remotely incoherent that there should be different answers. The second point, in any event, is, as we would urge on you, what has happened since the sewer judgment does not depend for its Turkish law validity on the sewer judgment. Independent legislation has been passed, independent court decisions have been made. And the other point that my learned friend urges on you is he says, oh, well, we do come within one of the exceptions to the rule that the English court will recognise foreign executive action, which, in our submission, the pleaded case simply doesn't do. It comes nowhere near the sort of the Oppenheimer and Cattermole test. We haven't gone to that, but you may recall. I'll just give you the reference, because the phrase used is something that is not law at all. Is the phrase used in Oppenheimer and Cattermole? That's in the Authorities Bundle 1. I don't ask you to go to it now, but just so you've got the reference. It's Authorities Bundle 1, tab 13.
So, I mean, might that potentially apply in the hypothetical situation I was putting to you a moment ago, where the SDIF purported to appoint someone as a director when it had absolutely no legal basis for doing so?
Well, my lord.
Well, where we get to, we haven't looked at Oppenheimer.
No.
My recollection of it is, I mean, that's an example, isn't it, of abhorrence.
Yes.
That's a case where
It was Nazi
laws on expropriation of the assets of Jewish people was so abhorrent to the public policy of this country and to international law.
Yeah.
After all, there was a tribunal at Nuremberg.
Right.
Following on from all that.
Exactly.
That
But we're just nowhere near that territory here, with the greatest respect. And my own friend made a valiant effort to suggest that the Venezuela case has somehow introduced a sort of a more relaxed test, so to speak, for ignoring executive action. But it just doesn't. We've seen what paragraph 135 says, and yes, it uses the expression contrary to English public policy. But Oppenheimer and Cattermole, and for that matter, the Iraqi, you know, we've also got the Iraqi Airways case, which was, you know, they basically stealing aircraft in the course of a war. Again, I mean, absolutely flagrant breaches described by the court there as an act of international piracy. That's not the world in which this case exists. Can I just actually, while I'm on that point, deal with one other matter? My learned friend has sought to suggest that there is some inconsistency between, on the one hand, our saying we accept that the question whether or not the sewer judgment, he keeps using the word corrupt. I think the index suggested it had been used 54 times yesterday in the transcript. We don't understand what he means by corrupt. That has connotations of, you know, brown paper bag. For the avoidance of doubt, the imputations against the sewer judgment in particular and the rule of law in Turkey are absolutely rejected. All we have said is that we recognise that the evidential basis upon which those allegations have been made are unsuitable for summary determination in this application. My learned friend seems to have carried that forward as if we are conceding that there is a tribal issue, as if we somehow say that there is something in all this. We don't at all. We simply recognise pragmatically that that kind of issue is not something that is capable of being determined summarily. And on the back of that pragmatic concession on our part, my learned friend then says, aha, well in that case it's inconsistent for Mr. Justice Trower to have said that we're not in Oppenheimer and Catamol territory because he's already accepted that he can't decide the matter summarily. With the greatest respect, there's no logic in that.
Apples and oranges
Well,
again,
exactly.
isn't it? Because you're dealing with a question of whether the foreign judgment is corrupt, whatever that means, on the one hand, but when we get to Oppenheimer and Catamol, we're dealing with foreign executive acts and legislation.
And what the judge was doing was essentially saying, even if what is alleged is true, that doesn't get to Oppenheimer and Catamol territory. That's not a concession. I mean, there's not a contradiction with our concession. You can't decide whether it's all true or not on an interlocutory basis.
Yeah.
So, and in fact, incidentally, I think with those submissions, I've also addressed my learned friend's appeal on ground too. He objects that Mr. Justice Trower was wrong to look at Oppenheimer and Catamol, and he came to the wrong answer. In our submission, he was right to look at it, as we point out in our skeleton. My learned friend's predecessor, in fact, invited the judge to consider Oppenheimer and Catamol, and in our submission, the judge was entitled to do so when considering this aspect of the case, and came to entirely the right decision. The only other point, just on this aspect, so we are at the moment, so to speak, at stage 2, that is, what is it that has to be recognised in Turkey, assuming something has to be recognised. I think I've also swept up ground 5 of my learned friend's appeal, where he complains that in paragraph 79 of the judgment below, the judge referred to various post-sewer measures. And in our submission, the judge was entitled to do so. In fact, the judge should have gone further and positively founded his case on those matters for the reasons that we've been exploring. But in relation to that, we don't have anything to add to our skeleton. So that's stage 2. Stage 2 is, if I'm wrong on the first point, and you do have to recognise something, what you're actually being asked to do is recognise legislation and executive acts which post-date sewer. Stage 3 of the argument. If we're wrong on that, does the judgment of the Turkish Constitutional Court provide a complete answer to any objections to the sewer judgment? So if we are looking to recognise something, and the thing we have to recognise is the sewer judgment, does the Turkish Constitutional Court judgment provide the answer? Again, there's the preliminary point my learned friend takes, that we didn't deal with this in the court below, and I've already taken you to our skeleton argument in the court below, where we did exactly that, paragraphs 115 to 118. We don't need to go back to it, but it's the supplementary bundle 2, tab 23. And it was indeed so apparent that we were taking this point that my learned friend's predecessor dealt with it at very considerable length. It is perfectly true to say, just by way of comment, that what the judge said, I think my learned friend tried hanging his submission that I hadn't run this point in the court below on what the judge below said in paragraph 82 of his judgment. When talking about me, he said, his oral submissions did not therefore concentrate on the question of whether or not there's a serious issue to be tried as to the integrity of the Turkish Constitutional Court. But the significant word there is concentrate. Indeed, I didn't. Orally, we put in front of the court our written skeleton argument. Twice in the course of my oral submissions, I emphasised that we were relying on everything in the skeleton, but I did what advocates often do in the interests of time and economy, which is not to expand orally on points that are fully covered in the written skeleton. And I made perfectly clear, as I say, twice in the course of all submissions, that we were not abandoning any point in our skeleton. For interest, if you wish, it's in the supplementary bundle to tab 45, at page 517, and again at page 526, I made clear that I was not abandoning the points. And as I say, it was so clear to Milan Friend's predecessor that these points were being pursued that he dealt with them at great length in his oral submissions. And I don't want to spend time on this, but just so that you get to turn a couple of pages. Supplementary bundle 2, tab 44. Is the transcript of day 1. And if we go to bundle page 466,
Yeah.
you'll see bottom left page, page 32 of the transcript, line 8. First of all, look at the review, the SIR decision by Judge Simler and also the Constitution Court. I think it should say the Constitutional Court, not the Constitution of the Court.
Yeah.
Because it's being said that whatever problems there may have been with that judgment were either addressed or could have been redressed in Turkey. So there's simply no scope, or at least no need, for an English court to refuse to recognise it. I'm just going to spend a bit of time on that, not really in our skeleton, so it may assist you. And he then goes on to do that, and he does so at greater length at page 2 pages on, page 468. That at the top right, transcript page 41, line 14. Mr. Atkins, there was then an appeal to the Constitutional Court, and he says whether you'll find that. My Lord, some reliance is placed on this by the defendant, so I'm going to need to be clear what the judgment was doing. And then he goes in to make essentially the points my own friend has been making. He says, well, it's not really an appeal court, blah, blah, blah. So, and that goes on for the following 13 pages of transcript, up to page 54 of the transcript. So it plainly was an issue in the court below, and indeed it is revisited yet again, page 475 of the bundle, transcript pages 67 and 68. So in our submission there is plainly no doubt at all that it was a point that was run in the court below. I didn't expand on it orally, but that it is nothing to the point. So, with respect, I am entitled to run it in front of you. Does it do us any good? Is the real point. Does the Turkish Constitutional Court judgment provide an answer to the attempt by Malone and Friends' client to invite this court on the hypothesis we're working on at this stage of the argument, to invite this court not to recognise the sewer judgment? Now, the thrust of Malone and Friends' submission proceeded as if we have to prove that the Turkish Constitutional Court is a court of appeal which re-examines de novo all the evidence and all the law in order to decide whether it would have decided in the same way as sewer. That just isn't the right question. The question is, when the English court is being asked not to recognise a foreign judgment because it is being said that that foreign judgment is, whatever it is, contrary to English public policy, the fact that it has been subject to bona fide scrutiny on review at an appellate level is an answer without this court conducting some sort of microscopic examination of exactly which points and what criteria are applied by the Constitutional Court. Recognition of a first instance judgment does not depend, a foreign first instance judgment, does not depend on proving that it has been subject to a full de novo appellate scrutiny. But even if that were not so, the Turkish Constitutional Court judgment is in fact a detailed consideration of the questions of fact and law that were the foundation of the Sewer judgment. And it is worth just turning a couple of pages of the judgment. It's in Authorities Bundle 2 at tab 40.
Supplemental.
I'm sorry, supplemental, you're quite right. Supplemental Bundle 2, tab 40. Because it's clear both as to what the jurisdiction of the court is from its own judgment and of the integrity with which the issues are addressed. So if we just start tab 40, just the first page of the judgment, page 417 of the bundle, identifies what it's grappling with. The application is related to the claim that the right to a fair trial and property rights, as well as freedom of speech and media, have been violated due to decisions of raid, seizure, and trustee appointment during prosecution for the crimes of management in a terrorist group, financing terrorism, embezzlement, and propaganda for a terrorist organisation. That, in a nutshell, is exactly the complaint that is being made in these proceedings as the basis upon which it is said that the Sewer judgment should not be recognised. And it is exactly what this court was grappling with, this Turkish Constitutional Court. We then turn the page, we'll see Roman 3, the incident and the facts. And we won't go through that, but you'll see it reviews what happened. And then at page 425 in the bundle, it identifies the relevant domestic law under Roman 4a. If I could just draw your attention on page 427. It specifically identifies, not entirely surprisingly, Article 133.
Yeah.
We then go on at page 431. Then reviews the approach taken by the European Court of Human Rights to the complaints that it is considering. And then at page 434, we'll see Roman 5, review and reasoning. A, the claim relating to the right of property is breached. That's the complaint. Applicant's claims and ministry's insights. The applicant initially expressed that the conditions in the law 5271, that's Article 133, related to the appointment of trustee, had not occurred in this case. According to the applicant, in order a trustee to be appointed to a company, there must be a crime conducted, not a crime conducted, there must be crime being conducted, not a crime conducted already. Also, the applicant asserted that there was no strong criminal suspicion which is needed to exist according to the law in this case. Besides, the appointment of a trustee was not registered and announced. The applicant, for these reasons, complained that injunction cannot be foreseen and was applied against the rule of legal clarity. Now, I read you that simply because it is part of my learned friend's argument to suggest that the Turkish Constitutional Court did not review the justification for the appointment of trustees under Article 133, and that is precisely what it did. Its assessment begins on the next page, 435, reciting the Turkish constitutional right, not dissimilar to Article 1 of the First Protocol. And then it deals with the issues. The language is not absolutely identical to Strasbourg language, but it is essentially the same progress between determining admissibility, determining the question whether or not there are property rights in question, whether there was an interference with the property rights, whether it pursued a legitimate objective, whether it did so pursuant to the law, whether there was a legal basis for what happened, and proportionality. It goes through all of, essentially, an analogue of the ECHR principles for determining whether or not what has happened is a violation of human rights. And you'll see on page 436, there's consideration of what they call acceptability, what the ECHR would call admissibility. And it holds over the page, paragraph 80, that the claim is admissible. So it then goes on under heading B with regard to merit, existence of property. Is there a property that has been interfered with? Paragraph 84, yes. Roman 2, type of intervention. You may recall that under Strasbourg case law, under Article 1 of the First Protocol, there's a differentiation between interference or control of property rights and deprivation of property rights. Exactly the same analysis is applied here. And not surprisingly, in paragraph 87, the court comes to the conclusion that in terms of that classification, this was a case of control, because it's management, a change of management, not a case of expropriation. And then Roman 3, is there a violation? And that deals with, again, exactly the same analytical framework as Strasbourg would, namely legality at the top of 439. Para 91, the first criterion to be examined in the interferences towards the right of property is the criterion of being based on law. So is there a legal basis for what happened? Answer, yes, paragraph 95. 2, slightly stranded heading at the bottom of the page, legitimate cause, what might be called a legitimate objective in Strasbourg language. And the answer to that is yes, bottom of the next page, at paragraph 100. Yes, there's a legitimate objective being pursued. And then again at the bottom of 440, the language is slightly different, but essentially moderation is yes, it's the umbrella term that includes what ultimately part of it is proportionality. I mean, I think it's sort of cumulatively it's really justification, because if we look at para 102.
Yes.
What they say is the principle of moderation consists of 3 sub-principles: compliance, necessity, and proportionality. And then it describes those, and in paragraph 103, it identifies, again, a concept well familiar to ECHR case law, namely a fair balance between personal rights and the public benefit. And then it goes on, page 442, I don't want to spend too long on this, but just so you see the clear approach that's been taken, it then deals with the application of the principles to that case. And I'm just reminded while we're there that one of the specific issues it was asked to address and does is on page 443, paragraph 113, the applicant stated that criminal justices of peace were courts that had been set up in defiance of the principle of I presume natural justice, and they're neither independent nor impartial. So that was part of the complaint. Now, I'm not asking you to agree with everything that the Turkish Constitutional Court said. That's not the question. You're not sitting in judgment on their judgment. what you're being asked on this, as I say, on this hypothesis as to this part of the judgment, of the analysis, is deciding whether or not the existence of this review by the Turkish Constitutional Court provides a sufficient answer to the criticisms that have been made of the Seward judgment for this court to say, we will recognise the Seward judgment, assuming that's what needs to be done. And in our submission, if you start micro-analysing the Constitutional Court, so to speak, the merits of the Constitutional Court's own evaluation of all those issues, you are committing a great big breach of comity. It is not a proper exercise to invite this court to sit, so to speak, as a further appellate court above the TCC, to pass judgment on whether you would have come to the same conclusion, or whether you think that they evaluated the evidence correctly, or whether they could have asked for more evidence, or whether they made the judgment on proportionality you would have made. That isn't the correct analysis. The question is whether the judgment, as it was said in Maximov, is so perverse that no bona fide court could have reached it. And in our submission, you just can't get there in relation to that Constitutional Court judgment. So all my learned friend's arguments, he said it's, as I say, his argument was that the Turkish Constitutional Court is not in the normal Turkish appellate structure. He said that it's not concerned with identifying errors of fact or law. It's to deal with fundamental breaches of human rights, and therefore he says the defects in the Seward judgment can't be cured. So I say all of that in our submission is an erroneous line of argument to be pursuing at all, because the question in this court is not, does the Turkish Constitutional Court provide a full de novo review of all the evidence and the law, but whether collectively you are being presented with a request to recognise judicial decision-making which is so perverse that no bona fide judge could have reached it. And secondly, and in any event, my learned friend's line of argument is, with respect, misconceived, or at least it's wrong. Because his complaint in the re-amended particulars of claim is precisely that there has been a comprehensive breach of human rights. That's the basis upon which he says this court should not recognise the authority of the Turkish directors. Precisely that point has been ventilated in front of the TCC, and it has rejected it. Why, in that situation, should the English court devote what will undoubtedly be weeks of time with expert evidence on the geopolitical situation in Turkey, the rule of law? We've seen how long the Jowl report is. We will have judicial experts, we'll have geopolitical experts. Why is this court being asked to entertain all of that when it is faced with a succession of judgments going up to, as I say, the Constitutional Court from the jurisdiction of a friendly state?
Well, it's not a case where it's said, for example, we ran the following points before the Turkish Constitutional Court, which it didn't deal with in its judgment.
Well, can I now take a pleading point validly? I want you to see what the appellants are in fact asking the court here to rule on. If we just look at the re-amended particulars of claim, paragraph 46.2, it is not in fact seeking to impugn.
Sorry, can you give me a
Oh, I'm so sorry. Sorry, of course. It's core bundle tab 14, page 170.
170.
170.
Yeah.
46, paragraph 46.2 It simply mentions the Constitutional Court appeal as part of a chronology. The pleaded issue that this court is being asked to grant leave to serve out in respect of.
Well, that's not quite fair, is it? What they're saying is the sewer judgment was itself unlawful, perverse, and Mr. Ipek couldn't get redress in Turkey.
For the breaches of the
for
right.
the bre-
But all it says is his appeal was dismissed. It doesn't say the Turkish Constitutional Court ruling is so perverse that it can't be regarded as a bona fide judicial ruling. It is not asking on the face of this pleading to impugn the
Is that the
integrity.
only reference to the Turkish
As far as I'm aware, it is. If I'm wrong, I will be corrected, but I think it is. It's just mentioned as part of the chronology. And the other point that we would make is that although the Jal report makes a large number of criticisms of a number of different elements of the administration of justice in Turkey, which, as I say, we do not accept, but let us treat it as a document which says what it says. As the judge below pointed out, we don't need to go to it, but it's para 79, the Jal report is as consistent with a finding that the Turkish Constitutional Court is independent, precisely because it does find against the government sometimes. And the problem that the Jal report identifies is that the Turkish executive simply chooses not to comply with Turkish Constitutional Court rulings. Now, that's an entirely separate point. What's being attacked here is the integrity of the Turkish Constitutional Court judgment. I don't ask you to go to it, but can I, sorry, just in the interest of time, can I very boringly give you a list of paragraphs in the Jal report where that point is made? Because the judge makes the point at para 79 of his judgment, but it is absolutely vindicated by what is in the Jal report. So could I just, with apologies for giving you a reading list, just give you a string of paragraph numbers in that report. So paragraph 72.2, sorry, the Jal report is supplementary bundle 1 at tab 13. And the passages which clearly support what the judge below said are para 72.2, para 75, para 86.4, paras 140 to 142, para 152.2, para 168.1, and paragraph 182. And the fact that the Turkish Constitutional Court is capable of providing effective remedies for alleged breaches of human rights has repeatedly been recognised by the European Court of Human Rights. So we've got a number of illustrations of that. I don't know if we particularly need to get them out, but in the case of Uzun and Turkey, which is Authorities Bundle 3, tab 47, tab 47, and the complaint, the ruling, and sorry, for this, no doubt, because it's translated from a French judgment, what we have call the TCC comes out as the CTC, but it's the Constitutional Court of Turkey. If we look at page 1777, you'll see that the complaint in that case failed for failure to exhaust domestic remedies because the matter had not been taken to the Constitutional Court.
Well, in 61, the court considers that the CTC provides adequate means for the protection.
Exactly, exactly. And we'll see the same thing in the next tab. Akin and Turkey, which a particularly relevant case for you to note because it was a complaint by a former judge about her arrest and dismissal following the coup. So precisely the kind of area where you might have thought if the European Court of Human Rights was concerned about political influence on the judiciary in Turkey, that would have been absolutely square front and centre of its decision whether or not the Turkish Constitutional Court provides an adequate remedy. And if we just pick it up at 1784, paragraph 18, the applicant explains that she didn't have an effective remedy to challenge her detention on remand. She states that 2 members of the Constitutional Court, as well as the rapporteurs working within the court, were arrested and placed in detention on remand. According to the applicant, in such a context, the Constitutional Court is not in a position to make an impartial decision. She adds that the measures taken pursuant to a decree law within the context of a state emergency are not subject to appeal. So essentially exactly the kind of point you've heard from my learned friend yesterday, and the court at page 1787, paragraphs 28 through to 30, the court considers that the applicant was required to bring an action before the Constitutional Court, which she failed to do, which she did not do.
22 and 23 make the point that you were making on 1785.
Yes. Yes, indeed. Indeed.
25, they give an example of a case where the Constitutional Court earlier in 2016 had ruled that the detention of journalists was unconstitutional.
And so one gets at paragraph 30 in a sense to the punchline. The application rejected for failure to exhaust domestic remedies. The European Court of Human Rights could not have done that if it didn't think that the Turkish Constitutional Court provided adequate remedies. There's another one where we don't particularly need it, but there's another example in the tab after that, Altan and Turkey, paragraphs 78 and 79, which are on page 1812, but I don't think we need to replicate the point. So the learned friend has made heroic efforts to suggest that the Turkish Constitutional Court is somehow politically influenced, but the one tribunal which is in fact vested with supervision of compliance with the Convention on Human Rights is unpersuaded by that. So where we get to on this point, which is, as I say, stage 3 of my argument, is that if you're against me on the first point, and there is something to be recognised, you're against me on the second point, and the thing that needs to be recognised is the Surah judgment. We do submit that the Turkish Constitutional Court provides the answer to that line of argument from my learned friend. That, I think, takes us to stage 4, which is closely comparable, which is that if you were against me on everything so far, the decision of the European Court of Human Rights itself provides the answer. Even if you weren't satisfied with the Turkish Constitutional Court ruling, we have the European Court of Human Rights' own decision. Now, there is just a preliminary point here. there is the Loudon Marshall application in front of you to get this judgment in front of you. You've already seen the judgment. The application isn't opposed, but just so that it isn't lost in due course, we will invite the court formally to make a ruling somewhere that the respondents are entitled to rely on this judgment. I'm grateful. The substance of the decision is worth looking at. And again, I just wanted to turn the pages without reading.
Can you just remind me, Mr. Crowe, because I've forgotten, when the court convenes as a committee rather than the full chamber, and what needed to do that?
Yes, the provision that we have actually, should maybe convenient to do it now if we can, just hand up, because it did occur to us that you might be assisted by seeing some there. Could I hand up some
When they deal
extra?
with issues of admissibility.
I'm sorry?
Is it when they deal with issues of
No,
admissibility?
oh no, it's not like the old commission. No, I think what it is you know, between ourselves, I suspect it's an effort by the court to try and get through its backlog. By sitting in threes rather than sitting in sevens.
That's rather what I thought, but I wasn't sure.
It has to be unanimous if they're sitting in committee. Could I then hand up a little clip of both extracts from the convention and also extracts from the rules, because we'll come to those in a moment. Oh, you've got the same. Oh, sorry. Okay. Yeah, ready. Thank you. Since we're on that, the convention itself, unfortunately, one has to read sideways. But if you look at Article 26, you'll see single judge formation, committees, chambers, and grand chamber. And it simply says to consider cases brought before it, the court shall sit in a single judge formation, in committees of 3 judges, in chambers of 7 judges, and in a grand chamber of 17 judges. The court's chambers shall set up committees for a fixed period of time. At the request of the plenary court, the committee of ministers may, by unanimous decision and for a fixed period, reduce to 5 the number of judges in the chambers. When sitting as a single judge, the judge shall not examine any application against the high contracting party in respect to which that judge has been elected. That then goes on to deal with various other administrative matters. Article 27 deals with competence of single judges. Article 28 deals with competence of committees. And it says, in respect of an application submitted under Article 34, that's a complaint, a committee may, by a unanimous vote, A, declare it inadmissible or strike it out of its list of cases where such decision can be taken without further examination, or B, declare it admissible and render at the same time a judgment on the merits if the underlying question in the case concerning the interpretation or application of the convention or the protocols thereto is already the subject of well-established case law of the court. 2. Decisions and judgments under paragraph 1 shall be final. Now, you heard yesterday from my learned friend that his client, Mr. Ipek, has asked the court to reopen the committee's decision. Our response to that is, good luck. But it doesn't have jurisdiction to do that. It will,
There's
I
no
think,
Taylor and Lawrence procedure in
the only is the ability under the rules to do what we in England can do when a draft judgment is circulated and it contains an obvious error. You can ask the court to correct an obvious error under the rules. And if an application has been struck out wrongly, it can be restored. But there is no provision under the convention or the rules for an applicant to come back and say, all right, you found against me, but would you mind having another go? So if we can just turn to
So what if the issue in the case was not already the subject of well-established case law? Then presumably, having declared it admissible, the committee would adjourn it to a chamber to
exactly.
deal with the merits.
Exactly.
But here there's no question that.
No, they've held it to be manifestly ill-founded because it can do so without further inquiry. So the judgment itself is in the Aladdin Marshall bundle, the skinniest bundle we've got at tab 4. And the pattern of the judgment, not entirely surprising because it's applying closely comparable provisions, it looks not entirely dissimilar to the Turkish Constitutional Court judgment in terms of structure and, as it turns out, outcome. So you start on page 30 of the bundle with the general context of the case, and it gives the factual background. And then over the page 31, we see the heading placement under the administration of a curator and its consequences. We go on to just those pages of facts, and then it recites the process that was followed. At page 34, you'll see the heading towards the bottom of the page, the appeal to the Constitutional Court. And it tracks through what happened there. And then page 38, section B, it looks at the domestic law. And page 39, we see the grievances. 2/3 of the way down the page, grievances. Relying on various provisions of the Convention, the applicant complained of violation of his right to respect for his property, his right to a fair trial, the principle of the legality of penalties and offences, his freedom of expression, and his right to respect for his private and family life. And I'm not going to read the judgment, but you will just see that it deals in turn with A, the complaint relating to the presumption of innocence. Over the page at para 73 is found to be manifestly ill-founded. Section B, complaint alleging the right to respect for property. And in that context, again, my learned friend suggested in his oral argument yesterday that it did not form part of the complaint, that the criminal peace judges are corrupt, I think was the word he used yet again. We don't know what the complaint was because Mr. Ipek has not put it in evidence, but what the court says in paragraph 74 of the judgment is the applicant complained that his group was placed under the administration of a curator by decision of the Justice of the Peace. He alleges that justices of the peace do not constitute judicial authorities in accordance with the requirements of Article 6 of the Convention and that they are not independent and impartial. So the best we can do is to infer that Mr. Ipek did complain that Sewer was politically influenced, or whatever phrase one wishes to adopt, to impugn the integrity of that judgment. We just go on then. We just look at page 41, paragraph 82. Court observed that this measure is provided for in Article 133.
Sorry, Mr. Crowe, wasn't Mr. Scott's complaint that the court only considered the A1P1 complaint and didn't consider the Article 6 complaint and took as a sort of starting point that the measure was ordered by an independent judicial authority in paragraph 84?
because it has already ruled on complaints similar to those of the applicant concerning the independence of justices of the peace and has declared them inadmissible. There is nothing in the present case to depart from that conclusion. So
that's
not
the
having been provided with the complaint or with the evidence supplied in support of it, all you can infer is that Mr. Ipek did complain about want of impartiality on the part of Sewer, and that was rejected because there was nothing that he had put in front of the court to cause it to depart from previous rulings that justices of the peace were impartial. You will see, I don't want to spend too long going through it in court, but you'll see the whole of this section from paragraph 74 through to 97. It goes through the complaints. The objection, so to speak, that Article 6 isn't addressed separately from Article 1 of the first protocol in our submission is a purely formal complaint. If there had been a deprivation of property that wasn't in accordance with the law because our Article 6 had been violated, it would have been caught up by that ruling. That's precisely why the court often chooses to deal with complaints by reference to a sort of headline issue, so to speak, precisely because the substance of other complaints are in fact captured by that headline issue. So it really doesn't do Malone Friend any good at all to point out, as a matter of form, Article 6 doesn't get its own subheading. So ultimately, really, where one gets to is that the court does what the Turkish Constitutional Court did. It went through, is there a legal basis? Is it pursuing a legitimate objective? Is it doing so proportionally? And it comes to the conclusion at paragraph 97 on page 43 that the complaints under Article 1 of the first protocol are manifestly ill-founded. And then it deals with the complaint about alleged breach of freedom of expression, and it says that that doesn't raise anything separate, and that is rejected too. Oh, sorry, yes, I'm grateful. I'm reminded that in paragraph 96, the court observes that the applicant may at any time request that the judicial authority to lift the measures and, if necessary, further matter back to the Constitutional Court, in particular if the duration of the measure should become excessive or if other factors should militate in favour of its lifting. Again, not something it could conceivably have said if the court in Strasbourg didn't think that the Turkish Constitutional Court provided an adequate remedy. Again, my learned friend approached this partly on the basis of suggesting that the European Court of Human Rights is not an appellate court, which considers it's not an appellate court from the national courts. Of course it isn't. We all know that. But the question in front of you is whether the fact that the European Court of Human Rights has reached the conclusion it has in relation to alleged fundamental breaches of human rights is sufficient to provide this court with satisfaction that the Sewer judgment should be recognised if that's what you need to do, if that's what you consider you need to do. And the answer to that doesn't turn on a minute examination of exactly the scope of jurisdiction of the ECHR. It involves holding up side by side the complaints that are made in the re-amended particulars of claim alleging fundamental breaches of human rights, and essentially the same territory canvassed in that judgment. Malone Friend has made a number of points in response. He says that the rulings of the European Court of Human Rights on facts would be inadmissible in this court. Well, that is with respect to a courageous submission, bearing in mind Section 2 of the Human Rights Act requires this court to take into account rulings of the European Court of Human Rights. and that remains the position. Whether our political masters leave it as such, only time will tell. But we've included in the bundle the most recent decision on the case, the Ellen Kane decision, which is in the Authorities Bundle 2 at tab 29. And if we just look very briefly at that, so Authorities Bundle 2, tab 29, and at page 1109, you'll see from paragraph 89, section 2 of the Human Rights Act confirms the importance of the case law of the European Court to the interpretation of the rights by stipulating that the court or tribunal determining a question which has arisen in connection with a convention right must take into account any relevant judgment of the European Court. The issue which lies at the heart of many of those judgments is the application of the margin of appreciation doctrine. As has been explained, that doctrine is central to the European Court's interpretation, blah, blah, blah. And then para 99 is significant for present purposes. I won't read it out, but what paragraph 99 it emphasises is what has been good law for some considerable time, which is that if a claim fails in the European Court, it cannot succeed in the domestic court on the basis of a claimed breach of human rights. So not only does the domestic court here have to take into account the European Court of Human Rights decision, it can't come to a different view. Now, if Malone friend says, well, I'm going to adduce different evidence here from what I adduced in the European Court of Human Rights, we are straight back into abuse territory, because he is, by that, attempting to have endless bites of the same cherry. He's had a bite in the Turkish Constitutional Court, he's had another go in the European Court of Human Rights, and he wants a third go here.
But as you rightly say, we don't know exactly what it was that he
No.
alleged before the European Court.
That's his
But
call.
we know what the European Court said about
Yeah.
it, paragraph 84. We've dealt with this point about Turkish justices of the peace before, and there's nothing here for us to reach a different conclusion.
Absolutely. Absolutely. So,
to the extent you say, to the extent that Mr. Scott's inviting this court to conclude that Judge Sir was impartial, corrupt, was partial, corrupt, whatever the expression is, he would be inviting us to go behind what the European Court has decided.
exactly. The last point, I've already covered the point that Malone friend says that the committee decision is subject to an application to reopen it. I've already answered that. We don't accept for one moment that the European Court has got jurisdiction to reconsider a final decision. But in any event, you, with the greatest respect, simply have to take your decision on the basis of the material and the facts as they now are. And the facts as they now are that judgment has been issued, it hasn't been overturned, and you will, with respect, have to give your judgment on that basis. The last point I just wanted to touch on in relation to the ECHR was this. My learned friend said yesterday in his oral submission that the European Court of Human Rights ruling was made on the basis of a different factual basis from that on which this court is proceeding. And to make that good, he said that the European Court of Human Rights proceeded on the basis that the Sewer judgment was not corrupt. Whereas, he said, this court is proceeding on the supposedly common ground that there is a tribal issue, that the Sewer judgment is corrupt. That, with the greatest respect, is a fanciful submission. The position, as I'm sure you appreciate, is that we, because this is an interlocutory application, have agreed that factual allegations of political influence over the judiciary in Turkey can't be decided at this stage. The European Court of Human Rights, however, was not dealing with an interlocutory application. It was dealing with the substance of a complaint of a violation, and it's reached a ruling having considered the evidence that's been put in front of it. In that situation, with the greatest respect, it cannot possibly be suggested that this court has to ignore the court's judgment in Strasbourg because we have conceded that it's not an issue that this court can decide summarily.
Yeah, but the concession you made before the European Court decision was reached.
That was going to be the next point. Exactly so.
So even if it were a concession, as it were a formal concession, which we would otherwise hold you to, you would submit. We shouldn't be held to it because this is what the European Court has said.
Exactly. Final point, not quite, but if I can just wrap up a few other points in my learned friend's answer to the European Court of Human Rights. One of the other points you made, he said, well, it's not determinative of English public policy. Well, as a matter of form, that is true. But where, as in this case, a litigant seeks to invoke English public policy on the basis of alleged breaches of human rights, it is, to all intents and purposes, determinative, because to suggest otherwise would involve flouting Section 2 of the Human Rights Act and paragraph 99 of Ellen Kane. I don't ask you to turn it up, but Milan Junior points out that having recited all the alleged breaches of human rights, paragraph 92 of the re-amended particulars of claim, so it's taking into account all the above, English public policy should say no. So it's perfectly obvious as a matter of substance that the English public policy claim that is being run is entirely premised on alleged breaches of human rights. The last point my learned friend made in relation to the ECHR ruling was that the trustees and Koza Ltd were not parties to it. Well, frankly, so what? The court has made a ruling on the basis of the complaint of the complainant. We're not invoking it in some sort of private law res judicata basis. We're putting it in front of this court on the basis that it is the single most material thing that the court will take into account when deciding whether or not it would be contrary to English public policy to recognise the sewer judgment, assuming that needs to be done. Just a couple of very short points, if I can, before the short adjournment, and that will get me to the end of this whole line of argument. Where we get to, just stepping back from the detail of the argument in relation to the European Court of Human Rights judgment, these appellants, are asking this court, well, the courts of this jurisdiction, not to recognise the sewer judgment, because they say it represents a violation of his human rights. The court that is charged with determining breaches of human rights has ruled the complaint to be manifestly ill-founded. These appellants are now inviting the English court to spend whatever weeks of court time redeciding that point. In our submission, that is simply an unrealistic submission to be making, and it is one that this court should have no hesitation in rejecting, even if you do follow the appellants, so to speak, in relation to the first couple of points that I've already addressed you on. The only other thing we just wanted to mention was this. Milano friend urged on you a passage in the decision in Ultimo. I think he was calling AK Holdings or something. I think it's generally referred to as Ultimo, in support of the proposition that the court here should be slow the court here should be slow to make a ruling before trial in relation to a point of law in a developing area. We have, for your edification, included a very recent ruling in relation to just that point. In the case of the Royal Bank of Scotland International, which is in it may not be necessary to get it out, but just so you've got the reference, it's Authorities Bundle 2, tab 31, and paragraphs 29 to 32. Essentially, the thrust of it is, well, yes, if findings of fact will inform the court's decision on a point of law in a developing area, then yes, it's going to be better to have a trial to find out what the facts are. But you cannot, as a general proposition, say you can never decide a difficult point of law in a developing area at an interlocutory basis, because you may well be able to do exactly that if it is not fact-specific. And the points that we are putting in front of you are precisely that the English court does not need to get into a factual quagmire investigating the rule of law in Turkey, going back on the pleadings, as you may see, to 2013. It simply doesn't need to get into that, because even assuming that there is something to be tried, assuming against myself that there is a triable issue on something, the combination of the various points that we have advanced are pure points of legal principle, which should be sufficient for you to dismiss the application for leave to serve out. That, having overrun very slightly, is all I wanted to say on the first main issue. That leaves us simply with the gateway argument for service out and the abusive process argument, which won't take more than an hour or so this afternoon.
And that give Mr. Scott enough time to reply?
I think we had agreed between us that he would be getting about half an hour, so he may get even more than bargained for.
Finished, isn't it?
We will certainly finish today.
Yeah, good. Okay, 2 o'clock then, please. Thank you.
All right.